Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and very good day everyone. So this is our group presentation regarding the case of Malayan Banking Berhad against Jin Huat Food Staffs Industries 2019. So let's go.
An introduction, I am going to touch briefly about the writ. Writ as most of commencement of an action. The writ must be served to the defendant once it has been issued. The plaintiff must comply with the rules of service on the Rules of Court 2012 for the principle of equal chance, so that the defendant will have an equal chance to enter into an appearance, make a counterclaim, and writ can be served by two ways, which is either personal service or prepaid AR. AR stands for Acknowledgement Written. So for the fact of the case, the issue arose after the plaintiff had sent a letter on 22nd May 2018 to the first defendant requesting to pay the amount due and owing under the banking facilities, but the first defendant default in payment. The amount due was from the banking facilities, which the first defendant had requested on the letter of offer on 23rd May 2013, and it has been already accepted by the plaintiff. And through the banking facilities, the first defendant had entered and committed various loan documents. Even the first, second, third, and fourth defendants had executed letter of guarantee to jointly and severally guarantee the payment to the plaintiff. So, after the default of payment, a letter from the plaintiff solicitor had been sent to the first defendant demanding to pay the outstanding amount under the banking facilities on 30. The first defendant received the letter on 30 June 2018, and the first defendant was supposed to pay 7 days after receiving it, but he ignored it and failed to do so. So the second, third, and fourth defendants received the same copy of letter from the plaintiff solicitor. In that letter, the plaintiff had terminated the banking facilities and demanding the outstanding amount under the banking facilities. The issue from this case is whether the plaintiff writ and statement of claim for repayment of outstanding amount under the banking facilities had been served to defendants properly without any irregularities.
The plaintiff had submitted all the requirements under the law, have been complied with, and the grounds that were put forward by the first defendant, alleging to set aside the judgment in default was bare denial. The plaintiff had submitted the certificate of indebtedness, which was one of the evidence that stated the amount due and owing it by the defendants. The first defendant claimed that the service of writ statement of claim were irregular. The plaintiff stated that they had duly served the writ and statement of claim to the defendant in accordance to the terms of loan and guarantees which was entered by both the parties. Defendant's contention. The first defendant had contended that the judgment in default was irregular, since the plaintiff had not served the writ and the statement of claim by the prepared AR registered post address as stated in the Order 10 Rule 1 of the Rules of Court, but the plaintiff had served the writ and the statement of claim by an ordinary registered post. Moreover, the first defendant had also stated that the plaintiff solicitor, Ms. Scrine & Co., proceeded to serve the writ and the statement of claim personally upon the defendants. Furthermore, the defendants claimed that the plaintiff did not provide any evidence of the service of writ and statement claim save for the list of posted registered items and there is no acknowledgement of service of judgment in default.
The judge dismissed the enclosure 8 with cause based on the reasons mentioned below. Firstly, the sum and payment due owed by the defendant to the plaintiff is clearly shown in the certificate of indebtedness of the plaintiff, excusing the plaintiff from proving the evidence of debt. Clause 22 of the letter of the offer says that any legal process may be done by the prepaid registered post or ordinary post to the address indicated. The appellant has actually followed the provisions in the loan agreements and guarantees. So in contrast to the claim of the defendants, the judge ruled that there is no irregularity in the service of the writ. Next is the respondent has accused that the plaintiff purposely served the writ and statement of the claim knowing that the defendant has represented by the solicitors. They find the support from the case of Mokhtar Amin versus Mokhtar Muhammad Omar. However, the approach used in that case can't be used here because no solicitors has came forward in the record in respect of the subject matter in this action of the writ and statement of the claim provided to the defendant. Hence, the case of Mokhtar Amin relied upon by the defendants is distinguishable from the present matter because no solicitors has came forward for the defendants. As to the defendant's contention that the plaintiff has not put any proof of service of writ and statement of claim and there is no any acknowledgement of the service of judgment in default, court finds that the list of kiriman banyak barang-barang daftar is a sufficient proof that the writ and statement of claim had been sent by registered post and deemed delivered. Moreover, the defendants one of the letter to the plaintiff requesting more time to settle their debt and also appealing for delay of legal action against them is a clear express that the defendant has admitted their debt. So, there is nothing more for the defendants to rebut or to dispute that the fact they now disagree with the court. Okay. For me, I think that there is no any irregularity in the service of writ and statement of the claim and also the judgment of default obtained by the plaintiff. So now the burden has shifted to the defendants to prove that they have defense on merits. But the defendants has not put forward their defense. Hence, the enclosure 8 is simply an attempt by the defendants to obstruct the payment of a clear-cut debt owing to the plaintiff.
Alright, thank you to my friend. Now we'll be moving on to my part, which is case analysis. Okay, in this case, the plaintiff successfully proved to the court the element cause of action is embedded in the term of the loan and guarantee document under the banking facilities. Through these clauses, the claim is substituted in suitable conduct to be inferred as statement of claim. These clauses are in line with Order 10, Rules 3, Sub-Rule 1 of Rules of Code 2012 that support the service of writ in a contract. The plaintiff also has served a clear and concise writ. Okay, there are 4 letters that sent to 4 different defendants. The letters are sent in a specific date and within the limit of time. The defendant also have received the letter and clearly aware with regard to the received notices. In fact, they also defendant that replied the letters for postponement of the default payment. As for the duration of settlement of statement, plaintiff in this case has stated that 7 days is the maximum days to receive the default payment under the banking facilities to the first defendant. The defendant also required to pay the owed amount before day 7 or this claim will be commenced before the court. The duration of this settlement is applied to second, third and fourth defendant as well. As the proof of substantial matters, okay, plaintiff in this case has successfully proved that defendant owed money from them through the certificate of indebtedness and the letter sent by defendant to request for postponement of the default payment. Okay, second, the defense of defendant regarding the irregularities of serving the statement of claim also rebutted when Order 10 Rules 3, Sub-Rule 1, give the extension to serve the service of rate through the contract terms and clauses. Hence, this has validated the plaintiff right to make claim through service of rate, as evidences adduced are in favor of plaintiff.
Now, on the part of commentary, we have to mention that this group is totally agreed with all the decisions that being made by the judges. Why? First of all, we have to agree that how the court have made a very critical finding when the court had mentioned about the certificate of plaintiff certificate of indebtedness. Now, why this certificate is very important, as we can see that now the court explained that with this type of certificate, now the burden of proof has shifted from from plaintiff to defendant. Now, must be clear to the court that the defendant now is the one who do deny the amount that being claimed and not the plaintiff. Well, in this key point, other than that, the court also had produced a very critical finding also when the court has stated that defendant had admitted about his debt when defendant had sent the letter to plaintiff requesting more time to settle the amounts that had been owed by him. So now, basically, in our opinion, we totally agree that when the court mentioned about that, because it is very important to see that defendant now had to prove, had the burden of proof had shifted to defendant, and now he is the one who need to prove to the court that the amount that be claimed should not be claimed by plaintiff. Now, secondly, we also agree with the opinion of the judges, which they stated that the plaintiff had duly served the writ and statement of claim on the defendant just according with the terms of the loan documents and guarantees that had been made between the parties. Now, in everything more about general rule, the judges had cited about the Order 10 Rule 3 1 of Rule of Court 2012. So, what else now defendant want to say? Other than the general rule, the court also sees and mentioned about the clause 21 and clause 22 of the contract between the parties, which mention about the direct or the right way to serve the service of rate. So now, this is a very critical finding that we made by court, and we are totally agreed about that. Other than that, we also think that the contention made by the defendant, which stating that the plaintiff does not provide any proof of service of rate and statement of claim, was not relevant at all. So now, I think the judges also made the same opinion, where in these findings, the judges had ruled that the list of kiriman banyak barang-barang berdaftar is a sufficient proof that the writ and statement of claim had been served via registered post and it deemed very delivered. So now, in our opinion, it is a very sufficient proof. But if the defendant does not agree with this opinion, the court had also cited the case of Hong Leong Bank Berhad against Stockmaker Enterprise at Sdn Berhad and others. So now there is a case where the previous judges also agreed that this list kiriman banyak barang-barang berdaftar is a very sufficient proof to the proof that should be provided to the court, in which to prove that this writ had been served well to the defendant. Lastly, we are also in the same opinion with the judges regarding the regularity of the judgment in default that be obtained by the plaintiff, as the defendant had no such merits in their defense to argue the judgment that had been obtained. So, yeah, regarding this issue, again, the court had ruled that the burden should be on the defendant and not on the plaintiff, which they need to provide their defense with such merits. So again, I have to conclude that this group are totally agreed with all the decision made by the judges, because the judges had made a very critical findings in deciding this case.
For the conclusion, when the first defendant requests an extension of time to repay the loan under the banking facilities, it is a clear admission of the debt. Therefore, the plaintiff has a good cause of action to serve the writ and statement of claims to the defendants. The first defendants appear to have no merits nor arguable case to allege that there is irregularity on the service of writ and statement of claim. In conclusion, the plaintiff has the rights to demand the outstanding amount due under the banking facilities, and the writ of service and statement of claim had been duly served